of Lisa Smith and Secretary of State for the Home Department.
My Lords,
Yes, Mr. Sally.
my Lords, my Lady, I appear for the respondent in this matter with my learned junior, Miss Smith. Mr. Tamking's counsel and Ms. Barnes appear for the Secretary of State. We did have some sort of discussions about the order of submissions because obviously formally this is the Secretary of State's appeal. However, we've raised the objection to jurisdiction, so the view of the parties, but obviously this is subject to anything the court may, any views the court may have, was that probably I should go first.
Yes, I think so.
Yeah. Thank you. And we have also come to an agreement about division of time, so I'm meant to be, I think, going for a maximum of an hour and a half. Can I apologise, firstly, for, I think there were some issues with the hard copies of the authorities, in that I think a number of the authorities, I think my learned friend identified them.
There's some rather random, bold type, and
yes.
I began by thinking, what's the significance of this, particularly in respect of one of my own judgments? And,
yeah.
But the answer is there's no significance, and
yes,
just ignore it.
I apologise for that. It seemed to be an issue with printing, because I think the electronic bundle doesn't have that problem. Also, two other sort of slight changes. One, my learned friend identified the fact that nobody, whoever produced the bundle, didn't identify the fact that Section 49 of the Competition Act is sort of has been repealed in a slightly odd way, or has been amended in a slightly odd way. Finally, I've also provided a copy of DH. That was an authority we'd agreed, it was in our skeleton argument, we'd agreed to omit, but having looked at what was said about discrimination, it seemed to me that it might be of assistance because it sets out the test for indirect discrimination. Obviously, our submission is that the issue of jurisdiction is an important issue. It has, whatever the court's judgment is, it has implications not just for the route of appeal, but for example, who can appear as a special advocate. And,
yes.
That's what's important. And obviously, similar issues could arise in Scotland. I'm going to refer to Ireland all the way through, but similar issues could arise in relation to Scotland. The difference may be that obviously in this case, we would submit that the issues before SIAC in this case did have, the legal issues did have a Northern Irish element to them. And I say that for this reason. We accept, of course, a point that is made in the judgments that are identified by the parties as being relevant, that immigration law applies throughout the United Kingdom. And so the respondents, the decision taken in relation to the respondent prevents her travelling to London as much as it prevents her travelling to Belfast. However,
where is she now?
She is, as I understand it, on bail in the Republic of Ireland. She's on bail for criminal. The criminal. I think there's still, as I understand it, criminal proceedings outstanding. Yeah.
In the Republic.
In the Republic of Ireland, and she remains on bail in relation to those. But the reason why I say there's an Northern Irish element to this is that in relation to the Article 14 argument, which is the argument that is actually resolved by SIAC and now is the subject of the Secretary of State's appeal, as is clear from the judgment of Mr. Justice Jay and his colleagues, the argument essentially, a significant part of the argument was whether there was a justification for the difference in treatment that we would say the respondent was subject to. And in that context, there were, as SIAC identified, issues essentially that arose in relation to both the payment of a fee and probably more importantly the oath of allegiance, and one sees that in the core bundle, page 41, paragraph 17. And at paragraph 18, you will see obviously that Mr. Justice J records the appellant's objection essentially to being to swearing an oath of allegiance. Not only was that effectively a factor, and obviously there are particular sensitivities in Northern Ireland about that. Indeed, I think there's a member of the Northern Irish Court of Appeal now who declined to swear the oath of allegiance. Not only are there sensitivities in Northern Ireland about that, the specific point that was being made on behalf of the appellant, which I accept obviously was not relied upon by SIAC, but would be a matter that would be renewed in the Court of Appeal, in whichever Court of Appeal considers this, was the Good Friday Agreement, and one sees that at paragraph 19 of the judgment, where there's reference to my submissions about that. And in essence, the argument was, as summarised there, the Good Friday Agreement, essentially, a key provision of the Good Friday Agreement is it allows someone to identify whatever their legal status as Irish, as British, or as both Irish and British. And so, for example, the scheme of the Act is that, for example, the appellant's father is able, even though he is technically a British citizen, to identify as Irish. But he gets the benefits of British citizenship. And that's why the Good Friday Agreement was being relied upon. Because what was being argued essentially was that the respondent, the appellant before SIAC, was potentially being required, if she was to benefit from British citizenship, to identify as British by taking the oath of allegiance, or at least applying to have that varied. Now that is significant. It explains why in the earlier judgment of SIAC, the judgment of Mr. Justice Chamberlain, dealing with the appointment of the special advocate, Mr. Justice Chamberlain accepted that, and this is in the supplementary bundle at paragraph 16, that proportionality would depend to some extent upon the appellant's claim effectively to be a member of a border community, and accepted that in terms of the open lawyers, and I'll come back to his reasoning in relation to the special advocates, there was good reason for the applicant to be represented by Northern Irish lawyers. And I should make clear that her open lawyers, in terms of her open lawyers, at that stage she was represented by Northern Irish solicitors. My junior has had a temporary dispensation to appear in this court, but is a member of the Northern Irish Bar. I'm dual qualified, effectively, and spend quite a significant period of part of my practice in Northern Ireland. So, even though I may not sound Northern Irish, professionally I am part Northern Irish. So, that, as I say, was identified as being a significant factor. Now, that's, in terms of the facts, probably all that's relevant, because obviously this is an issue of principle. The reason I draw attention to those facts is simply to demonstrate how, in our submission, it is important to recognise that although a tribunal like SIAC is UK-wide and applies primarily UK-wide law with slight sort of additional qualification that in this case there was this particular factor arising as a result of the Good Friday Agreement, but it is clear, and this is consistent, we submit with the case law, that decisions on SIAC can have particular implications for devolved, for people who are in devolved administrations. It can effectively have effect, the decisions of SIAC, in particular devolved administrations. Turning then to the legislation, the SIAC Act, the relevant parts of the SIAC Act are at page 20 onwards of the authorities bundle. and the particular provision that deals with appeals is section 7. And section 7, subsection 3, defines appropriate appeal court, and it defines it on the basis that where a determination is made by the Commission in England and Wales, it is this court that is the appropriate appeal court, and where the determination is made by the Commission in Northern Ireland, the Court of Appeal in Northern Ireland is the appropriate appeal court. And in our submission, that language of determination being made in a particular location has two possible interpretations. The first is that it refers to the physical location where the determination is issued from. The problem with that is, well, there are two problems with that. Firstly, it doesn't necessarily say anything about the nature of the issues.
Well, you say issued from. I was thinking of it in terms of where Mr. Justice Jay and his colleagues sat.
Yes. Well, this was the second problem that the reason why I said issued from is that having thought about it, one of the things that obviously in a post-COVID world we're aware of is that physical location may be quite difficult to pin down. So if one thinks about the history of this matter, you have Mr. Justice Jay sat, as far as we can remember, and last 24 hours we've been racking our brains to make sure because we anticipated this question to make sure we could accurately remember, because it was a remote hearing. Mr. Justice Jay, because he was sitting with a panel, we believe sat in Field House, but he was obviously the participants were both in England and Northern Ireland.
I understand that.
Yeah.
But I mean, please tell me if this isn't so. But I thought that Mr. Justice Jay and both his colleagues were physically present in Field House.
I think that's right, as far as we can remember. But
that Ms. Smith's team were appearing remotely. I don't know about the Home Secretary's team. Were they remote? Or?
Yes, it was in the days when everything was remote, so they were remote.
Right.
But the reason I slightly hesitate about that, and sort of added complication, or identify an added complication, because it does demonstrate how things move, is that having, again, sort of given thought to this, our memory is that Mr. Justice Chamberlain, when he dealt with this matter, because he was sitting alone, may well have been sitting in the RCJ in his chambers.
Yes, well, yes. I mean, there was a stage when we did things from home, but it would still be in England.
I'm not suggesting it wouldn't, but the point I'm making about it, obviously if it was in the RCJ, it would be in England. But the point I'm making is that one of the problems with physical location, my lord, I use the language of determination being where the determination was issued. My lord put to me, isn't it effectively where the Commission was sitting when it carried out the determination? The only point I was making is that when you think about what happened in this case, which was influenced by COVID, it demonstrates in one sense the difficulty sometimes with pinning down physical location, because there were a number of physical locations that were used or may have been used for parts of the hearing, effectively, depending on whether you focused on the panel, whether you focused on the participants, and which panel you were talking about. And it demonstrates effectively that in a, as I say, in a post-COVID world, physical location can be slightly more difficult to pin down.
But if one looks at the wording of Section 7, it says, where the Special Immigration Appeals Tribunal has made a final determination. Well, isn't the issue where the final determination takes place?
Well,
because if you read the entirety of that section, it ends with the word determination as well, on any question of law material to that determination. So aren't we really focusing on where, in fact, the panel was sitting to make its determination?
Well, the alternative meaning that I was going to put was that what determination means, and it is that what the provision as a whole means is that when looking at where the determination was made, one is looking at where the determination had effect. The Tehrani approach, effectively, which is to focus on the practical implications of the determination.
Well, you'll no doubt be taking us to Tehrani. It's obviously an important case. You could do it now, or as my lady's raised the subject, or if you wanted to come to it a bit later, we can come to it a bit later.
I was going to come to it a little later, but partly because it's important, I think, to look at the statute as a whole, because obviously a point we make is you read the statute as a whole, and there are at least two other relevant provisions. The second provision, obviously, that is of some significance, and it's one of the reasons why in our submission it is potentially difficult to apply the principle that Section 7, or apply the approach rather that Section 7 should depend on where the determination was issued, is that Section 6 deals obviously with the appointment of special advocates, an issue that arose in this case. It essentially provides that for the purposes, if one goes, that's at page 21, for the purposes of proceedings in England and Wales, you need to be a special advocate to have a qualification under Section 71 of the Courts and Legal Services Act 1990. And if proceedings are in Northern Ireland, the special advocate needs to be a member of the Bar of Northern Ireland. Now, that in our submission, logically, it's one of the reasons why it is important to look at the statute as a whole, because in our submission, it would be somewhat surprising if Section 6 were to treat proceedings essentially as proceedings in Northern Ireland, but Section 7 were to then require an appeal to the English Court of Appeal. One would assume that the intention was that proceedings that were proceedings in Northern Ireland would result in an appeal to the Northern Irish Court of Appeal. But obviously Section 6 has to be phrased in different terms to Section 7, because the assessment takes place at an early stage, because you're looking to appoint someone before there's been any determination issued. That's why the language is different. It is also, in principle, at a stage where, well, at the moment, SIAC is only authorised to sit in the field house. In principle, there could be more than one location used for a SIAC hearing. If, for example, case management was conducted in London, but the hearing took place in Belfast, physical location could vary during the course of proceedings. And so Section 6 in our submission is phrased in terms that are intended, essentially, we would submit, to recognise those realities. And that's why the language is proceedings in Northern Ireland. And in our submission, that language, again, is potentially consistent with focusing on where a determination will essentially have effect.
You could have a case where, as you say, case management or interlocutory hearings were dealt with by a judge sitting in Belfast, Edinburgh, Newcastle, if she happened to be there, as it were, but the actual final determination, which my lady rightly focused on, was in London.
Yes.
But any particular stage of the case, the proceedings, can only be in one place, can't it? I mean, even if case management took place with the judge happened to be sitting in a circuit town or in Belfast or in Edinburgh or something, the final determination when it happens can only be in one place.
Yes. Well, yes. Well, that may depend. Sorry, the reason I slightly hesitate about that just is this. We've noted, I think, in our skeleton argument that that's probably right. But the one qualification we've put to that is that if one focuses on effect, which we submit one should, then I suppose in principle it may be possible for a determination to have an effect both in Northern Ireland and in England. It's probably unlikely, but the reality is that Tehrani, for example, we would submit, anticipates that any decision will have a greatest effect in one place. Yeah, but yes. But the point I'm making really about Section 6, and the reason I'm referring to Section 6, is that Section 6 has to be applied relatively early in proceedings because it's concerned with the appointment of a special advocate. At that point in time, it may not be clear whether the determination will be issued because case management could take place in a different place in principle to the final determination. That suggests that what Section 6 is concerned with is not where physically the determination is going to finally be issued. It's concerned with some other concept, and the most likely concept we would submit is because that's the easiest to assess at an early stage, is where the determination will have effect. And if that's right, that in our submission sheds light on the correct approach to Section 7. I mean, if you think about the position before Mr. Justice Chamberlain, where he was effectively dealing with a case management issue, who's dealing with who could be appointed as special advocate and who could be appointed as open advocates. At that stage, he knew that there'd been no authorisation issued for anywhere other than London, so that gave him some indication of where the substantive hearing would be issued, but obviously he didn't know whether or not that might change.
Can I just, sorry to interrupt, Mr. Sully, but there hasn't been a request to the Lord Chancellor at any stage in this litigation.
We wrote a letter.
You did?
We did write a letter after the judgment of Mr. Justice Chamberlain. We never received a response.
What, wrote asking the Lord Chancellor, whoever it was, at that stage to give a direction for Belfast.
For Belfast, for there to be a hearing centre in Belfast.
And you never challenged the failure to respond?
We never challenged the failure to respond.
So at the moment, there is only one place that's ever been designated for SIAC to sit?
At the moment, as far as we're aware, yes. We don't take issue with what is said by my learned friend in his skeleton argument. Certainly that's our understanding as well.
Can I just ask you one point on your proposition that it's where this takes effect?
Yeah.
At the material time, your client was 10 miles from the border in Northern Ireland, wasn't she?
She was.
So why did it take effect in Northern Ireland and not England, Wales or Scotland?
Well, the reason it took effect in Northern Ireland was that her position essentially was that she wanted to be able to cross the border because that's part of life in a border town, effectively.
No, I appreciate that, but you said take effect in rather than at the time of the determination. That's her future intention was to do that, but you say if you're trying to formulate a test that we would then have to apply, but actually you've already qualified by it, saying actually it affected her in her plans to go to Northern Ireland, which is not taking effect in Northern Ireland.
Well, except we would submit it is, to this extent, taking effect in Northern Ireland, in the sense it's preventing someone effectively going to Northern Ireland who has ties with Northern Ireland, yes. I mean, perhaps an alternative way of putting it, and I may have been using a shorthand that perhaps oversimplifies the approach in Teherani. A better way of putting it may be to say that the litigation had strongest ties with Northern Ireland. That might be a better way of putting it.
Thank you. Sorry to interrupt.
No, that's.
But sorry to keep harping on about this, but if you're right that Section 7(3) of the Act can be interpreted so that determination made by the Commission equals determination taking effect in, then seems to me you win.
Yeah.
But a determination can take effect in lots of places. A determination that suppose the Commission decides that an exclusion order excluding an individual from the UK is perfectly all right and valid. That takes effect in Northern Ireland and Scotland and England and Wales. But in contrast, it seems to me at the moment, if determination made means made by the judges where they're sitting, it can only be made in one place.
Well, that's why, in some senses, I in response to my Lord Justice Dingemans' question to me, perhaps clarified the language I was using and made it clear that I accepted that was probably an oversimplification of Teherani. What Teherani was, we would submit ultimately identifying was that in a piece of litigation, essentially, involving immigration cases, there is likely to be, perhaps inevitably will be, one of the devolved jurisdictions or England and Wales that has greatest ties effectively with that litigation. And that may be a better way of putting it rather than having effect. Having effect may be one of the factors that feeds into that, quite an important factor potentially, but ultimately Teherani involved an assessment of a range of factors, including where the individual was living, where any removal, because that was a removal case, would take place, where hearings had taken place as well.
Shall we look at it then? Or do you want to put it off further?
I would put it off just a little bit further. If I recognise it's at the heart of my, because obviously so that we don't lose sight of it. I've drawn attention to Section 6 and the sort of set complications that arise from Section 6 because of the fact that the assessment essentially of Section 6 takes place before any determination is issued. And obviously, Section 6, two things can be said about it. One, it is plainly intended to ensure that a person or a team of people continue to act as special advocates throughout the case. It would be surprising if you kept having different, it would be hugely resource intensive for a start if special advocates change at different stages.
I don't know. Do SIAC special advocates play a part at interlocutory stages?
They can do. They can do. Yes, it depends on what the interlocutory issue is.
Particularly on disclosure and issues beforehand, yeah.
Exactly. And also, what for example can happen is you can have effectively treated as an interlocutory. You can have sort of separate issues. So, for example, in a nationality case, you might well have whether the individual is a dual national or not, and they can occasionally, that dual nationality issue can occasionally have closed elements to it. Certainly.
Yes.
Mr. Southey, will you just bear with me? This is lack of clarity on my part.
No, sure, it's mine.
You mentioned now the concept of where the greater ties are for the individual in question.
Yeah.
Just help me as to this. How does that build in to whatever test you are saying should be applied on Section 7?
What I'm saying is that if one looks at Section 7 and the language of Section 7, Section 7 in my submission can be interpreted essentially in two ways. One is obviously what the Secretary of State would argue for, what is being put to me, which is simple physical location. Yeah. The other is that determination made in England and Wales, essentially, or Northern Ireland, refers to a broader concept of the jurisdiction, essentially, with which to which the case has strongest ties. And so made in England and Wales would mean that the litigation is essentially tied to England and Wales in a Tehrani sense.
The special advocate issue,
of
course, was dealt with by Mr. Justice Chambers.
Yes.
I assume at some point you're going to take us to his judgment and tell us what you think he got wrong.
I will do. Yeah. I will do. Yes. I mean, he obviously did accept that there was a Northern Irish legal issue involved, which is why he dealt with the open issues. But he was obviously focused on the issue of the appointment of special advocates, and to a certain extent focused on the human rights arguments raised in relation to that. So I will come back to that. The final provision, this is what I didn't want to lose sight of before coming to the case law, is obviously Schedule 1, Paragraph 4, which is the provision that provides that the Commission shall sit in places that the Lord Chancellor may direct. And obviously that is expressed in different terms. The language is different to Section 6 and Section 7. We submit that it's an unsurprising provision, partly in light of the fact that there clearly need to be security arrangements. There would be a security implication. If a judge were suddenly to say, I'm going to have SIAC sitting in my back garden or whatever, there would be obvious security implications in that. But it's not necessarily the same as Section 6 and Section 7, and we would submit that the language of Schedule 1, Paragraph 4 is different, partly because, as I say, it's concerned with a different issue. What we would submit, though, reading the statute as a whole, is critical, is that SIAC is clearly a UK-wide tribunal. It was clearly recognised that as a result of that, there may need to be appeals to the courts of appeal, the appeal courts rather, to be more accurate, in devolved jurisdictions. That is in a context, as I say, where it may be the case that appellants have particular ties with those devolved jurisdictions. Now, the authorities, we would submit there is no authority directly on point, and I'm not sure this is in dispute, there's none. The first authority in time, I think, is, and I can deal with it pretty briefly, is the authority of Gardaí, which is at page 51, which dealt with an appeal from what was then the Immigration Appeal Tribunal, and the statutory scheme was, from reading the judgment, pretty similar. And in that case, it just seems to have been assumed, see paragraph 5 of the very short judgment, that physical location was determinative. It certainly doesn't appear to have been any argument about it. What it does demonstrate is that if we're right about jurisdiction, the order of Lady Justice Laing needs to be set aside, because in fact in Gardy the appeal had been determined before the issue had been identified. Tehrani, though, it follows that, and that's...
But the paragraph 5 of this short judgment shouldn't be overlooked, should it?
It's paragraph 5. I pointed to paragraph 5.
Yeah, no.
Sorry.
You did, but
yeah.
the fact that they said the appropriate appeal court, defined as paragraph 23(3) set out, and went on to say this case should therefore have gone to the Court of Session and not come to us. I agree that's pretty short and sharp, but it's rather significant, isn't it?
Well, I don't deny the fact that it is obviously contrary to my case. The problem that one has with it, in my submission, is firstly it's unclear whether there was any argument at all about that, and secondly, because the judgment is unclear, is so brief, it's also unclear whether there would have been any serious argument that applying what I've described as the Tehrani approach, Mr. Gardy had any particular ties with, or the litigation, perhaps more accurately, it's unclear whether the litigation had any particular ties with England and Wales. There's no reason on the face of the judgment to believe that was the case. So the issues that arise in this case may well not have arisen in Gardy. One simply doesn't know.
Okay.
Gardy is then followed by Tehrani, which the relevant passages. Well, actually, the first passage to go to, probably, because it's fair to say is sort of consistent with Gardy, is the judgment of Lord Roger at page 170, paragraph 107.
Sorry, which page?
Page 170 of the authorities bundle, page paragraph 107. And what, in particular, by letter E, the sentence starting, but in the present context, that sentence certainly appears to be, say, consistent with Gardy, in the sense that it's indicating that it is the determination of the physical location of an adjudicator that determines which would be the correct appeal court. However, it then follows by making the point that essentially it makes sense for the review jurisdiction essentially to be the appellate jurisdiction, which, if Tehrani is correct, and obviously it's binding on this court in terms of what the review jurisdiction should be, is not necessarily going to be the case if it is just physical location that determines appealed, because the whole point, in one sense, of Teherani was to indicate that a wider range of factors could potentially be taken into account.
Well, yes, but it's a judicial review case.
It is.
Now, I found Lord Hope at paragraph 60 quite helpful, although it's not sidelined. The Court of Session has jurisdiction in these proceedings at common law. He disagrees with the extra division, that's the inner house, that the court's supervisory jurisdiction does not extend to the determinations that were made in this case because they were made in England. And then he sets out 3 factors which indicate there's a sufficient connection with Scotland for the supervisory jurisdiction to be exercised. Lord Roger says similar things at rather greater length.
Yes. Indeed, I think Lord Hope's Para 60 is built effectively on, or reflects also what he said at Paras 50 to 52, I think. He made similar, perhaps slightly expanded remarks.
Yes.
My lord, he did, but in one sense, that's the point I'm making about what is said by Lord Roger at paragraph 107, where he talks about it making practical sense for the review court and the appellate court to be in the same jurisdiction. That would suggest that the appellate court ought to be determined in part on the basis of the sorts of factors identified by Lord Hope in Para 60, because what he's doing there is essentially, it goes back to the answer I gave to my Lord Justice Dingemans. What he is doing there is recognising that the assessment of the ties to a jurisdiction that exist in a particular piece of litigation is essentially multifaceted. It partly may depend on where a tribunal sits, but it also needs to take account of other matters, such as where harmful effects were liable to be felt. And as I say, the problem with my learned friend's position in my submission is it results in a situation where, if one were to apply the Teherani test in our submission, and had there been a judicial review of SIAC, we would submit Belfast was the correct location for that judicial review. But Belfast isn't the correct location then for for an appeal, if my learned friend is correct.
That's not really what Teherani says. I mean, Teherani says, really, the judicial review should go with where the appeal court is. But because of the particular difficulties in that case, including the fact the Secretary of State hadn't taken the point on jurisdiction, time had elapsed, then it was fine to leave it, given that there was jurisdiction to be exercised in exceptional circumstances.
Well, I would say that Teherani goes a little bit beyond that, and I mean, if one uses paragraph 60, for example,
yeah.
As a summary of and I certainly would accept that paragraph 60 is consistent with the other passages that have been highlighted. The factors that are identified as meaning essentially that there is sufficient connection with Scotland are where the harmful effects would be felt, where the individual was resident, and the fact the jurisdiction extended throughout the United Kingdom. That last factor is a factor here. What one does have in this case, in one sense, which makes it a stronger argument in our submission, is that in this case, unlike the Teherani case, where, as one sees from Lord Hope, paragraph 50, in Tirani, the legal issues were essentially UK-wide issues. They had no particular ties with any of the jurisdictions. Here you have the added factor that the legal issues do have a particular relationship with Northern Ireland, do have a particular tie with Northern Ireland.
Yes, of course they do. I mean, speaking for myself, if this were a forum conveniens argument, what's the most suitable, most appropriate forum for this to be held in? I'm said Belfast, of course, but this isn't a question of an application for judicial review. If the challenge to an exclusion order could be made by ordinary common law judicial review, then presumably you would have made it in Belfast. But the appeals are regulated by the SIAC Act, and so the question, as it seems to me, is what is the appropriate appeal court for the purposes of the SIAC Act, not what would be the most desirable forum if we were starting from scratch.
But my lord, with respect, the way that you've just put that to me raises, in one sense, highlights that I suppose what we are saying about the issue of statutory construction, in the sense that physical location, if the statutory construction ultimately is physical location is determinative, that produces a problem in our submission, because it means that this litigation ends up in this court, which is a court which we would certainly argue doesn't meet the forum's convenience test or the approach. But the reason it doesn't meet that is quite an important issue, which is that it is this issue of effectively the Good Friday Agreement, the particular impact in Northern Ireland, and that is where case law we cite, Berkeley, makes it clear that the Northern Irish Court is going to be better equipped effectively to deal with the issues. And that, in our submission, means that it is unlikely effectively that Parliament intended to have that effect of requiring effectively an English court to resolve issues that have a very distinct Northern Irish element to them.
Okay.
So, my lord,
what else do we get from Tehrani?
Well, my lord, I think probably, I mean, we've highlighted the relevant passages we would highlight are 49 to 52 and 100 to 104. But I accept that a few things from those, which I think are probably not have been put to me in questioning. One is that ultimately the issue in Tehrani was a separate issue because it wasn't dealing with directly the statutory provisions that are in issue. It wasn't dealing with any statutory provisions. It was looking at which jurisdiction should effectively try a claim for judicial review in circumstances where more than one jurisdiction had jurisdiction to try the claim for judicial review. The approach it adopted to that was essentially multifaceted. It was to look at the ties of the individual to a particular place, the ties of the litigation to a particular place, in the context of a legal system that was clearly UK-wide. It did, in paragraph 107, which is why I drew attention to it, touch on the issues that are engaged, but in one sense made remarks that point in different directions, because although it appeared to indicate that the appeal would be determined by location, it equally indicated that it made sense for effectively the review jurisdiction to be the same as the appellate jurisdiction. And we would say what Tehrani indicates is that the review jurisdiction in this case, were there to be a review, would be Northern Ireland. Indeed, the case for it to be Northern Ireland the reasons I indicated, is stronger, effectively, than the case in Teherani. I think that probably, in summary, covers all I can get from Teherani. Teherani, though, as I say, should be viewed. I made reference a moment ago to Berkeley. Can I just draw attention to Berkeley? Yeah. Berkeley's at page 44, or the relevant passage of Berkeley is at page 44 of the appellate bundle, para 39. Again, I accept this is not concerned, obviously, with a statutory appeal system and an appeal system in particular that prescribes the rights of appeal. And what Berkeley makes clear in paragraph 39 is that we're assessing proportionality, and ultimately in the Article 14 case, obviously proportionality is a key issue. Indeed, it was probably determinative in this case. Local courts essentially are in the best position to do that because they are aware of the cultural tradition, I think is the language in the judgment, cultural traditions and national context. It's an issue. Certainly we would submit if the courts of the Channel Islands are better equipped to deal with the sorts of issues that arose in Berkeley, the courts in Northern Ireland are equally, if not better, equipped to deal with the issues, the sensitive issues that arise in this case. One needs to remember Baroness Hale put it very strongly in that she described the courts of the Channel Islands as being infinitely better to assess the issues.
But just let's deal with the practicalities of this case. In open session, you and Miss Smythe would represent the individual.
Yes.
Yes? You have clearly considerable experience appearing in Northern Ireland.
Yeah.
Miss Smythe is a member of the Northern Irish Bar.
Yes.
Speaking for myself, I used to see it as my duty as an advocate to ensure the court was as fully informed as it could be of all relevant matters. Isn't that your duty?
Absolutely. I'm not suggesting that if argument occurs, it takes place rather in England, that we will not do our best effectively to alert the court to, as we tried to before sighing, to alert the court to the relevant provisions of the Good Friday Agreement, for example, and draw attention to the particular sensitivities of the Good Friday Agreement. It is just, but I mean that would have applied in Berkeley. The difficulty is that, of course, and this is, I suppose, a strength of the judiciary. Any judge comes into court with knowledge of their own society. They're in one sense a representative of the society they come from, and I no reason to believe that with respect to the court, this court, any of the judges have particular Northern Irish ties, essentially, and
well, nor did Mr. Justice Jabe.
What?
But he found in your favour.
Yes, he did. But I'm not saying. I mean, I'm equally not saying, obviously, that this court would necessarily find against me. I'm not. It is just. I mean, in one sense, I accept on our argument, it was probably less than ideal that Mr. Justice Jay was the tribunal. But there was, in one sense, that we didn't have any argument in relation to that.
And that it was held in London.
Well, the physical location may matter less than the identity of the judge. I mean, the point being made in Berkeley is not that it's really important that the hearing takes place in the Channel Islands. It is that you have Channel Islands judges who understand the cultural traditions and of the Channel Islands and national sensitivities, essentially, of the Channel Islands. National context is the language used. And that's the point. I mean, the Berkeley would suggests that if you had Channel Islands judges sitting in London, there wouldn't be a problem. It was the identity of the judges that was the concern.
I'm sorry, which was the paragraph?
Paragraph 39, page 44. And page 45, top of page 45 is where Baroness Hale talks about judges in the Channel Islands being infinitely better placed.
Of course, if there had then been an appeal from the courts in the Channel Islands, it would have worked its way up to the Privy Council.
Well,
in London.
And
it doesn't really matter. It's an issue of jurisdiction.
Well, Baroness Hale deals with that and explains that on the basis that the Privy Council ultimately, because of its experience of sitting across a large number of jurisdictions, being in a position to show sensitivity to local judges, essentially. So she deals with that argument, basically.
I thought that judges of the Courts of Appeal of Jersey and Guernsey were almost invariably English practitioners who are
and Scottish
and Scottish and
yeah.
Welsh. Yes.
Well, I'm conscious. Somebody who sits as a judge in another jurisdiction, many miles away from here, I'm also conscious of the fact that that is not an uncommon feature. But I suspect, and Baroness Hale doesn't deal with that, the argument, or the position, what she would suggest is that by reason of appointment to another jurisdiction, you ultimately have a responsibility, I suppose, to know something about that jurisdiction. But I'm conscious of the fact that obviously there are a number of jurisdictions where judges travel quite a lengthy distance.
Anything else from Berkeley?
And nothing else from Berkeley. It's just, as I say, the point we take from Berkeley is that Berkeley demonstrates how, in a case like this, there is real value in having Northern Irish judges involved in determination of obviously what's quite an important issue. The final authority that I should just touch on, not that we say it has, I think it's raised by an infringement skeleton argument, but we would say it has very little relevance because of the different statutory scheme, is KP Pakistan, which was dealing with appeals from the upper tribunal, and it's a judgment of my lord, that would just have been, where, but the obvious difference is that if one goes to page 73 of the authorities bundle, paragraph 14, ultimately the upper tribunal is required to specify essentially which is the appropriate appeal court. Perhaps of some relevance that of course it's implicit in that scheme that physical location may not be determined. That's presumably why the upper tribunal is required to identify which is the appropriate jurisdiction. But because that provision is there, in one sense, well, no, in an obvious sense, the issues that arise in this case weren't present there. All of that in our submission means that say we would submit that given the fact that it is recognised C. Tehrani that litigation such as that in issue can have ties with can have stronger ties essentially with another jurisdiction other than the one in which SIAC happens to physically sit. And given the value essentially in having local judges determining issues such as those in this case, it would be surprising effectively if the statutory scheme didn't operate in the way we described. We have raised human rights issues, in particular in relation to the issue of the instruction of counsel, and the argument essentially is that Section 6, if operated in a manner which ties the appointment of special advocates to a particular location, it potentially raises human rights issues, and that as a result Section 6 should be read as focusing on essentially the Tehrani test, for want of a better phrase, and if Section 6 is read in that way, Section 7 should also be read in that way. And we put the human rights arguments in two ways. Firstly, we point to the Article 6 case law, and we do that, I should make that clear, not because we argue Article 6 is directly in play. It is plainly not in play in circumstances where what is an issue is immigration status. The reason we can rely on it, we submit, is because Article 47 of the Charter applied at material times, and Article 47 of the EU Charter essentially included a right to representation in civil proceedings as well as criminal proceedings. I can see my lord looking slightly quizzical. The provisions of the Charter are in the authorities bundle. The Charter is at page 7 of the authorities bundle. And one sees at the top of page 8, Article 47, which provides in the second paragraph in Article 47 the right to a fair hearing, in other words the Article 6 rights, but not qualified in the way that Article 6 is, so that Article 6 only applies, as is well known, to civil and criminal proceedings. It's not qualified in any way. And that provides, as a second paragraph, a second sentence rather, within that paragraph, the right to be represented, essentially. My lords will remember, we haven't included Article 6, that contrasts with Article 6, where the right to representation is within section Article 6.3, which only applies to criminal proceedings. And Article 52 of the Charter makes it clear that rights are at least as extensive as the ECHR, but can go further. It's Article 52.3.
I hadn't spotted the EU point, but Article 47 says nothing about being represented by a lawyer of your choice.
But that's why we refer to the fact that standards are at least equivalent to ECHR standards, and ECHR does the ECHR case law, and we refer to Maguire as being the leading authority in this jurisdiction, makes it clear that under Article 6, there is a right to representation by counsel of choice, subject to, and Maguire endorses the judgment of the European Court of Human Rights in Croissant, which is why Croissant is not in the bundle. It's page 85 and 86, the relevant passages, subject to there being a right to override where there are sufficient reasons. Now, we would submit, obviously, that the Northern Irish barrister whom the appellant wished to instruct was clearly personally suitable. there's no issue taken about his personal suitability. Indeed, I think he's now a High Court judge in Northern Ireland. There was in our submission particularly good reason why choice should be respected in this matter, which is that SIAC is, as this court has indicated, there are inherent unfairnesses essentially which have been authorised by Parliament, but they are inherent unfairnesses in the SIAC procedure, and as a result, it's important they're balanced out. And the third point we make is essentially that the case obviously had, as Mr. Justice Chamberlain indicated, had a Northern Irish element to it. Now, the approach of Mr. Justice Chamberlain essentially was set out at paragraphs 40 onwards of his judgment, which is in the supplementary bundle. And he started by indicating that it would be, or finding rather, in paragraph 40, that it would be impossible to suggest that a rule that prevents those without a right of audience in England and Wales from appearing in the courts of England and Wales infringes Article 6. That's his first sentence in paragraph 40.
Sorry, just let me catch up.
Sorry.
Yes, which paragraph?
Paragraph 40.
Yes.
Paragraph 40, in our submission, fails to, with respect to Mr. Justice Chamberlain, adequately engage with the fact, of course, that the tribunal is a UK-wide tribunal. It was a UK-wide tribunal dealing with a case that had a specific Northern Irish element to it, as Mr. Justice Chamberlain found. And so preventing the instruction of a Northern Irish advocate who certainly qualified to appear before courts of one part of the United Kingdom, in our submission, it is potentially difficult to justify, contrary to the approach in paragraph 40. What Mr. Justice Chamberlain then went on to conclude was, and this is in paragraph 41 by the lower hole punch, was that one further reason why essentially it was acceptable to and justified to require people to have special advocates to have a right of audience in England and Wales was that it was desirable essentially for someone to appear before the Commission who could also then appear in the Court of Appeal. But that, in one sense, produces, we would submit, a circularity, because it's assuming that the approach to appeals is determined by physical location, if, in fact, there is good reason why account should be taken of wider factors, and those factors should be taken into account in the Section 6 assessment, then that suggests that Section 7 is similarly flexible and permits account to be taken of the wider range of factors. We accept, and this is why I started by drawing attention to Section 6, that there is obviously a relationship between Section 6 and Section 7. But if Section 6, from a human rights point of view, needs to be interpreted in a manner that allows someone to choose their special advocate of choice, subject to there being some other reason for objecting to them, then that, in our submission, has a potential impact on Section 7.
What the respondent would like to have the right to do is to propose, she can't actually choose,
Yes.
a leading special advocate who is qualified in Northern Ireland but not here.
Yes.
Mr. Schofield has been removed to the bench.
Yes.
Mr. Straw is dual qualified, so there's no problem.
Yes.
But she wants the choice to have a replacement special advocate who is not dual qualified.
Well, that was her initial position. Obviously, her initial. I mean, for these purposes, in one sense, the issue is not so much the particular choice that she was making at that stage. It's about the statutory scheme in one sense, because it's the point in some senses that we're making is that if Mr. Justice Chamberlain is correct, she is constrained to elect to have a leading special advocate who is qualified in England and Wales.
But no one has the right to choose their special advocate, do
They don't. But subject to this point I would make, which is this. In practice, which is why this issue arose, the general practice is for special advocate support office to send out a list of special advocates, invite an appellant to select. Now, one of the reasons in our submission they do that is because, see Maguire, there is good reason to respect the choice of the individual. Now, obviously, because of the security issues, there is a need potentially to vet a special advocate. So what happens in practice, for example, is that there are issues that the security services, as I understand it, will carry out a tainting exercise. So they will look, because obviously if the special advocate has acted enclosed in relation to linked matters, there is a risk that they will then accidentally, not deliberately, put into to open something that is potentially sensitive, and that's always the concern. But subject to that, that's why that exists, and that obviously we would accept would be a good reason for Maguire, in Maguire terms, for objecting to someone. Subject to that, I mean, if the Secretary of State were to say, I'm sure, not the Secretary of State, the Attorney General were to say, I'm sure this would never happen in practice, but it's a way of testing it out. You've asked for Special Advocate X. They're ginger-headed. We don't want work going to ginger-headed special advocates. You're going to have Special Advocate Y. That would be, in our submission, prima facie challengeable on the basis that you're denying someone their advocate of choice without good reason.
But the hypothetical ginger-headed advocate was, on this hypothesis, was somebody on the list?
Yes.
Because you have no right to suggest somebody who's not on the list.
But again, that's because looking at the Maguire test, there's good reason for security, for somebody being security cleared, because they've got to have. But that then raises the issue, and this is the way, in our submission, Mr. Justice Chamberlain approached it. That raises the issue of, is physical location, which is effectively how he approached it, a good reason essentially for denying choice? His approach was essentially to say that because the Commission is going to sit in London, and because it is going to then result in an appeal to the English Court of Appeal, it is legitimate for the list you can choose from to be restricted, so it's only English and Welsh counsel who can be appointed. And our answer to that is essentially to say, well, that is to some extent circular in the sense that it's assuming effectively that the statute operates in the way that the learned friend argues it operates, we would submit that the importance essentially of having an advocate of your choice suggests, and that the obvious relationship between Section 6 and Section 7 suggests that Section 6 and Section 7 should be viewed in the way we argue it is, because that then avoids this problem. It allows someone to have their advocate of choice, providing they've got good reason. I mean, if this were someone, just to again sort of expand on that, if this were someone who, for example, had lived all their life in London, who clearly wanted to return to live in London, who had no ties with Northern Ireland, who simply wanted a Northern Irish special advocate because they wanted to cause chaos effectively or disruption to SIAC, one can see then that it might be open to SIAC to say, well, actually, this case clearly needs to be held in England. You've got no ties with Northern Ireland. You're simply trying to create disruption. In those circumstances, we don't accept effectively that there's good reason to instruct a Northern Irish special advocate. But this isn't that case. This is far from that case. And so, in one sense, one can look at this. There are two ends from which one can look at this problem. One can look at it from sort of, in one sense, the way SIAC has, which is looking at what the statute says about appeal rights, looking at where the appeal is going to end up, and then work backwards. Or you can look at it from the end we would say one does, which is look at the start. What do you know about the nature of the proceedings? Look at who should be appointed as special advocate, and interpret the appeal proceedings in light of that.
Did anyone suggest that Mr. Schofield should apply to get called to the English bar?
I don't remember that being suggested at the time. It may well be, I'm trying to remember the chronology of it, that he was appointed to the High Court bench fairly soon after, I think, the hearing before Mr. Justice Chamberlain.
Because in the way you've been called to the Northern Irish bar, some of us have been called to the Northern Irish bar, and people in Northern Ireland called to the English bar. There's a greater changeover than perhaps there is with Scotland.
Well, certainly, I think that it's fair comment to say there's a greater overlap between the English and Northern Irish bar than there is in Scotland.
Has anybody ever challenged the absolutely rigid barrier which the faculty of advocates and the Court of Session erect against English barristers? I'm certainly aware of a case where a litigant in employment tribunal case had their English barrister of choice in the employment tribunal in Scotland, and in the EAT sitting in Edinburgh, because there's nothing anybody could do about it. The litigant had the right to be represented by anybody, qualified or not. In the same case, got to the Court of Session, the Lord President and his colleagues told the English barrister to leave the court. That's how they do things in Scotland.
I'm not aware of anyone having sought to challenge it, and it actually is a particular problem that's arisen in immigration. I've not had it, but in immigration, because of the statutory provisions, if you, and this has been a real bone of contention among the English bar, in immigration, if you start off, which is not impossible, in an English detention centre, so you are represented by English solicitors and an English barrister is instructed by them perhaps to do the preparatory work, and then you are moved to a Scottish detention centre, so that you then appear before an adjudicator in Scotland. Unless the hearing is remote, because that raises different issues, my understanding is that you're not allowed to appear in the even though it's a UK-wide tribunal, you're not allowed to appear before the first tier tribunal in Scotland. And that has raised real concerns and real problems for practitioners.
Anyway, we're getting a bit off.
Sorry, yes, no, sorry.
Yes, I started that hair running. All right. Do you want to show us anything else from Mr. Justice Chamberlain's judgment?
Well, I need to just deal with Article 14 briefly as well, and we've set out in writing the arguments about Article 14. Mr. Justice Chamberlain I mean, in deals with it, but just to put it in context, we would submit it's pretty clear. C at ex parte S, or sorry, Queen on the application of S, which is at 124 of the bundle, S in the Chief Constable of South Yorkshire Police. As is well known, that there are 5 questions that need to be determined when determining whether there's been a breach of Article 14. They're set out in paragraph 42 of the Supreme Court judgment. Do the fact matters fall within the ambit? Is there a difference in treatment? Is the treatment on prescribed grounds? Is the situation analogous? And is there a justification? And there is an overlap, as recognised in paragraph 43, particularly in relation to the last 3 of those issues. In terms of ambit, because this is, I think, an issue that is in dispute between the parties, we would say very simply that Article 8 does, where Article 8 is an issue, and this was an appeal ground, which obviously was never needed to be resolved because of the way in which SIAC dealt with Article 14 as a preliminary issue. In Article 8, in the context of Article 8, there are procedural rights that arise in the immigration context. See paragraph 57 of IR versus the United Kingdom, which is at page 65, which specifically dealt with SIAC, in fact. And Mr. Justice Chamberlain assumed that this matter was within the ambit of Article 8. The difference in treatment in our submission arises because those with ties to England, those based in England or with strong ties to England, can instruct English special advocates to appeal to the Court of Appeals. So they can benefit essentially from relevant specialist knowledge. Those with ties to Northern Ireland are denied that specialist knowledge. That is, we would submit on the basis of status, and we recognise it's not directly on the basis of status. That's why we produced DH, because it sets out the test to be applied in the context of indirect discrimination for Article 14 purposes. And indirect discrimination, the test for indirect discrimination has the measure disproportionately prejudicial effects on a particular group. That's para 175, which within the report is page 117. And our submission is this, that while it is correct, obviously, that in principle, an English person, an English resident or a Welsh resident might wish to instruct a Northern Irish special advocate, the reality is that specialist Northern Irish legal knowledge, which is what really is an issue, is more likely to be relevant to Northern Irish or Irish residents and Irish nationals. It is Irish residents and Irish nationals who are more likely to wish to travel effectively to Northern Ireland and raise issues about Northern Irish communities.
But was the special advocate anything to do with that in this case?
Well, had we come to Article 8, for example, and we hadn't come to Article 8 because this was dealt with by Article 14, but at the time Mr. Justice Chamberlain was looking at it, we were looking at all the potential appeal grounds. In the context of Article 8, specialist knowledge potentially was of relevance in the sense that the proportionality assessment would need to have taken account of the particular factors that arise in relation to border towns. I mean, the appellant was essentially arguing that normal life in a border town involves crossing into and out of Northern Ireland regularly.
Well, I know that, and I have no connection with Northern Ireland. I'm trying to grasp what the special knowledge that a special advocate would need to have, not available to be told in the initial instructions or briefing from the client in open session, and not known by the open proceedings legal team consisting of yourself and Ms. Smythe.
Well, can I answer that question in this way? I'm not saying necessarily that the knowledge was... It's very difficult to, probably in any circumstance, to say that particular knowledge is essential, because when you're looking at sort of experienced leading counsel, you expect them to be able to pick up knowledge and develop knowledge about the way in which particular parts of society work. They may well not have lived in particular. But at the same time, from an individual's point of view, when an individual is selecting who will represent them, it is legitimate in our submission for an individual to say, I am looking for someone who understands my case, really. And if for example, I'm just trying to give an example, but which doesn't sound too sort of remote, but maybe this is a way of dealing with it, is if someone is, for example, raising a question about planning, and planning is not an area I know a huge amount about, so I may get the law wrong in relation to this, but if they're raising the sort of issue, they're raising the sorts of issues about, for example, the extent to which a proposed development is consistent with a local development plan. It would be legitimate for them to say, well, I know that any planning lawyer will understand the legal issues that arise in relation to this, but I am going to choose out of the significant number of lawyers who are potentially qualified to argue this case, someone who happens to, I know, live in that area, because I know they will understand the particular sort of issues that concern me. And that's really the point we're making, is that the Northern or the Irish appellant in the position of this appellant is entitled to say, yes, it may be the case that English or Welsh or Scottish advocates can take on board the points I want to make to them, but I'd rather have a Northern Irish advocate, because I can have confidence in the fact that they instinctively know what I'm talking about, effectively, because that's the society they've grown up in. And that's the point we'd make about differential treatment. It's not that English advocates are inherently unable to take on these points. It is that there is a natural, and one needs to remember as well that, of course, special advocates are in a very difficult position when they argue cases, because whereas my clients get to see me all the time argue the case, and if they think I'm doing it wrong, they can sack me. Special advocates don't come under that scrutiny, and so it's particularly important in one sense that their clients isn't the right word, but I'm not sure what is the right word, that the people they're representing have confidence in them. So, my lord, that's why we submit that knowledge is potentially important. It's an important part, we would submit, in the role of a special advocate. Obviously, the key role of the special advocate is to try and balance the inherently unfair aspects of SIAC, and one of the ways they have to do that is by ensuring that the person they're ultimately representing has confidence in them.
And the status on which you found the Article 14 argument is what?
Irish residence or Irish nationality. We put it on both grounds.
Right. I mean, suppose there was a SIAC appellant who was Welsh and said, well, this list of special advocates has got no Welsh people on it, so this is entirely unsatisfactory.
Well, the way in which that, properly in my submission, one would analyse that is by the 5-stage questions. You would get to, if we're right on our analysis, justification. The justification in that case would presumably be any special advocate has to be security cleared because of the sensitivity that they need to have in handling the material. There is nobody who has sought security clearance. That provides our justification. The difference here being, of course, we know that there were Northern Irish special advocates who had the necessary security clearance. And you might, it depends on the intensity of review, and we perhaps don't need to get into that, but it might be, in terms of the Welsh special advocate example, hypothetical, that there would then also be issues about the extent to which adequate efforts have been made to obtain a Welsh special advocate. But we don't need to get into that. But would it ultimately turn on justification? And the justification would be different. And ultimately, in our submission, Mr. Justice Chamberlain's analysis really, paragraphs 42, going back to his judgment, which I hadn't left, were it's paragraph 42 and 43, I think, of his 42 and 44 of his judgment, which is at page 21. That's 42. 42 is him identifying the fact that there are plenty of special advocates in England and Wales willing to travel. That, in our submission, doesn't necessarily mean that there are not good reasons, essentially, for someone to seek a Northern Irish special advocate. And obviously, a Northern Irish special advocate we would submit meets the security concerns. Paragraph 44 is perhaps more important in one sense, whereas he indicates that in his view there's no particular disadvantage and there is a justification in the appeal rights. The justification in terms of the appeal rights, I think I've already addressed. We would submit that assumes essentially that Section 7 isn't influenced by Section 6, and it goes back to the point I made about a lot of this depends on which end, effectively how one looks at this. Does Section 6 influence the approach to Section 7 or vice versa? In terms of no particular disadvantage, I think I've dealt with that already. The point I made about knowledge, essentially, and the need for confidence in one's special advocate. So that, I think, probably deals with Article 14.
Yes.
There are two other points we addressed in our skeleton argument because they were specifically raised by this court. One was the concurrent or exclusive jurisdiction. I think I answered that in a question in response to a question from my Lord Justice Bean. The other issue, which I think I've also touched upon, which is that if we were correct about Northern Irish jurisdiction, what is the position with the order granting permission?
I think that's pretty clear.
From guarding.
If if the appropriate appeal court is the Court of Appeal in Northern Ireland, then Lady Justice Laing's order is not worth the paper it was written on. It's a nullity. On the other hand, if we do have jurisdiction, then the grant of permission stands.
Exactly. I don't think there's any dispute. No. Thank you. I think that covers everything. Can I just... Thank you.
Right.
Thank you.
Thank you, Mr. Sully. Mr. Tapp.
May it please the court. Many of the submissions I've prepared to make, we've set out on paper, and indeed with the observations that the court has made, I know I can take some of them very, very swiftly.
Yes.
So let me try and be as concise as I can. The first thing to say is that this is, at its heart, a question of statutory construction, is what Section 7 means. And we would urge the court not to lose sight of that. That ultimately is a question that has to be answered. There are three preliminary points I'd make at this stage. One is that, the first one is that is a hard-edged question of jurisdiction. This isn't a question of discretion in any way. And I think that really is common ground now between the parties. The second point is that the substantive issues are not before the court today. And so I'm not going to say much about them. The only observation I think I should make is that Learned Friend did refer to some matters which are not uncontentious. And in particular, when he says that the Belfast agreements allow people to identify as British, whatever their legal status. These are things which may have to be argued out at a later stage, and I don't want silence to be taken as assenting to that. And the third is that there are obviously plenty of dual qualified practitioners who would be able to appear in SIAC proceedings in England whilst being Northern Irish qualified. Learned Friend has identified himself as one of those, and of course the special advocate, the then junior special advocate at the time of the hearing before Mr. Justice Chamberlain, was appointed then one of Her Majesty's Council, now one of His Majesty's Council, and no doubt is eminently well placed as a dual qualified practitioner to be the respondent's leading special advocate. Can I just say a word about the statutory provisions? I don't think I need to turn them up because you've seen them. The three that are important to look at together are, first of all, in the SIAC Act, first of all, paragraph 4 of Schedule 1, which is the Lord Chancellor directs where the site should sit. Yes. Secondly, it's Section 6 about the appointment of special advocates and the relationship between the qualifications necessary and where the site proceedings are. And the third is Section 7, the appeal right itself. We've made the point in our skeleton argument, I don't think I need to ask you to turn it up, that where the phrase appropriate appeal court is used, that is an identifier and it's not any sort of indication of discretion as between the courts. They are three mutually exclusive options, and that is really the only way that Section 7 can be read. So those are the statutory provisions with which the court is really concerned. Can I say a couple of things about the facts of this case? And I stress I don't advance these by way of criticism, but because they are important to understand why we are where we are with our appeal before this court today. The first is, as is common ground, there is only one direction from the Lord Chancellor, and that is that SIAC should sit at Field House. You see that in the 17th of April 2020 letter from SIAC, setting up Mrs. Justice Elizabeth Laing's views, as she then was, her views about the conduct of the case. And then also sorry, let me just give you the reference for that. It's in the supplementary bundle at pages 5 and 6. You'll see that. And then it was referred to by Mr. Justice Chamberlain at page 11 of the supplementary bundle, paragraph 14. And as Learned Friend has told you, there's been no follow-up and no challenge to the fact that the Lord Chancellor, having been asked to make another direction for SIAC to sit in Northern Ireland, has not done so. And the result is that where we are is that there is still only the one direction. and that SIAC has no alternative but to sit in Fieldhouse and only at Fieldhouse. As a matter of ordinary language, there is therefore no plausible alternative to the factual conclusion that Mr. Justice Chamberlain reached at paragraph 23, that's supplementary bundle page 14, that the determination was made in England and Wales. It's a matter of speculation about where we might be if learned friend had taken further the idea of asking the Lord Chancellor for a further direction and actually perhaps got a positive decision from the Lord Chancellor. It might have been to make a direction, and then we would be in different circumstances altogether, or there might have been scope for a challenge if the Lord Chancellor had refused to do so, and the Lord Chancellor could then justify the decision to insist that SIAC only sits in London with all the procedural consequences that entails. But none of that happened, so we are where we are. The second aspect of the fact is that Mr. Justice Chamberlain's decision itself was also not challenged. You'll recall from, it sets out very clearly at paragraph 46, supplementary bundle page 21, his conclusion that the SIAC proceedings were proceedings in England and Wales, and therefore that the only special advocates who could appear were English special advocates. And that conclusion has not been challenged. It is a facet of us being where we are, because what then happened with the appeal, as it happens, there were no further closed elements to the preliminary issue, because that was that Mr. Justice Jay's decision on the preliminary issue was done entirely in open.
Okay, so there's no closed judgment.
There was no closed judgment, no. But that is just as it happens. It would have been theoretically possible for that preliminary issue to have involved a closed element, in which case English special advocates would already have appeared and taken an active part in the proceedings that led to the respondent's appeal being allowed by SIAC. Another hypothetical alternative might have been that the respondent had failed on the preliminary issue, but then we had a full appeal, and then there would have been special advocates enclosed in the conventional way, English and Welsh special advocates, appearing there. And then if the jurisdiction point was then raised by the respondent at this point in time, we would have had a situation where the respondent was contending that these were Northern Irish SIAC proceedings, in which case the special advocates who had actually acted would have had no statutory locus to do so at all. And so it is unfortunate, even if the respondent may not technically be entirely bound by her failure to challenge Mr. Justice Chamberlain's decision, it is unfortunate that we are where we are on this, that the proceedings have been determined in England and Wales, and potentially it could have been with the assistance of English special advocates. So those are the 2 points on the facts that I wanted to mention.
If Mr. Justice Jay and his colleagues had decided the preliminary issue the other way, they were the Secretary of State, what would have been the next step?
We would have then launched into the full-on substantive appeal on the facts.
About whether the exclusion order, as it were, can be challenged on its merits as opposed to on Article 14.
Yes, we would have gone on to the full merits challenge.
Yes,
right. Our basic submission is very simple, and I won't labour it. It is as set out in paragraph 2.6 of our skeleton argument, which is in the additional bundle at page 29, or loose if you have it loose. The steps are simply that the appeal was before SIAC in England and Wales, and that's as Mr. Justice Chamberlain said. the determination was therefore made in England and Wales. The Section 7 provides that there is one and only one appropriate appeal court. And that is this court, England and Wales. And that we say that when you look at Section 7 and what has happened in this case, there is no other way, and there is no other conclusion that can be reached. So that is. So I'm not going to labour that, and I'm not going to repeat myself there. But can I say a word about the contrary proposition that Learned Friend is putting, which is to the effect that, based on Tehrani, that the determination should be regarded as having been made in Northern Ireland if it takes effect in Northern Ireland or its closest connection is with Northern Ireland. And we respectfully say that that submission actually assumes a lot of things which are not necessarily true. One has to remember that the determination of SIAC also takes effect in England and Wales and in Scotland. It's an exclusion order that is under challenge, and the effect of the exclusion order is that the respondent is excluded from all parts of the United Kingdom. So just to get down to practical brass tacks, she is excluded at all ports of entry, whether they're in England and Wales, Scotland or Northern Ireland. So it is far from obvious that the determination that SIAC makes has the closest connection with Northern Ireland, even if the respondent herself personally has a closer connection with Northern Ireland than with any other part of the UK. But there is also a rather more fundamental legal objection to the submission, which is that erecting a test of that kind turns the clear structure of Section 7 into an unworkably vague and uncertain mess for trying to work out which of the appeal courts has jurisdiction in any particular case.
Those are quite strong words, really, aren't they? But it may be said that when I pressed Mr. Southey this morning as to what exactly he was meaning and how one should put it in terms of connections, that really does demonstrate that it is sometimes an ephemeral concept.
It is. We respectfully agree and adopt that.
Really, you say there could be a discretionary decision or a forum conveniens type of decision if that's what the statute had provided for, but it doesn't.
Exactly so.
Yeah.
Exactly so. And indeed, what one might say, and I don't dispute the proposition that there may be SIAC cases which absolutely cry out to be heard in Scotland or in Northern Ireland. But the solution is not to mess about with what the statute means. The solution is to ask the Lord Chancellor for an appropriate direction to allow that sort of hearing to happen. But it hasn't happened in this case.
Well, if it has happened, silence hasn't been challenged.
Yes, I suppose what hasn't happened is that process has not been taken through to a definitive conclusion.
Yes.
So that's a basic submission. We say that is supported by two statutory construction arguments. The first is the purposive approach. This is really the putting Section 6 and Section 7 together to see the coherence of the scheme in which special advocates who are qualified in one of the jurisdictions would then, under the statutory scheme, appear in the appropriate appeal court if there is any appeal from SIAC's determination. Lots of good reasons for that. We've set them out in the skeleton argument. It's just a Chamber set them out. I don't need to repeat those. And so that is, if you look at more widely at the statute, taking Section 6 as well as Section 7, you see that also points in the same direction. So that's the first of the statutory construction arguments. The other is the contrary one, which is that Parliament could have, but did not, make a different provision that would point in a different direction. In our skeleton argument, we have set out 3 examples of situations in which Parliament has done so. That's it, paragraph 4.1. It's page 33 of the additional bundle if you're working from that. Can I just take these so that the court can see them? The first one is the Gardaí situation, and this relates to the 1999 Immigration and Asylum Act. I don't think we've actually looked at that statute. Can I just ask to turn that up quickly? This is in the Authorities Bundle, tab 5, page 14. It's paragraph 23, 1. If the IAT has made a final determination, any party to the appeal may bring a further appeal to the appropriate appeal court on a question of law. And then at subparagraph 3, appropriate appeal court means if the appeal is from the determination of an adjudicator made in Scotland, the Court of Session, and in any other case, the Court of Appeal. So Parliament very specifically fixed the route by reference to where the adjudicator had made the determination, not where the IAT had done so. And that, I regret, was where we all went wrong in Gardaí, because we failed to, if I remember correctly, we failed to spot 3 words in one of the top corners of the front sheet that said heard in Glasgow, and that was how it came about. And the consequence, because of the equally clear but different statutory provision, was that that appeal had to go to the Court of Session. The second example that we cite is the Competition Act 1998, and this is the provision which I hope you now have in tab 1 of the Authorities Bundle. It's the page which would have been numbered 3, but I fear we weren't able to get page numbers back on it. It's a new sheet that's gone in at the beginning. You see that the section 49.1 is an appeal lies to the appropriate court from a decision of the tribunal, etc. And then if you go over the page to 49.3, in this section, the appropriate court means the Court of Appeal, or in the case of an appeal from tribunal proceedings in Scotland, the Court of Session. Now that in itself is not very illuminating, but if you turn over to page 5 of the bundle, you'll see the tribunal rules, which allow, at Rule 18.1, allow the tribunal, after taking into account the observations of the parties, tribunal may at any time determine whether any proceedings or part of any proceedings before it are to be treated for all or for any purpose, including a purpose connected with any appeal, as proceedings in England and Wales, in Scotland, or in Northern Ireland. So specific statutory authority for the tribunal itself to say these are to be treated as proceedings in Scotland or Northern Ireland, or of course England and Wales. Just for the court's note, the rulemaking power is somewhere in the Enterprise Act 2002. The citation is buried in Mr. Justice Chamberlain's decision somewhere, but that's where this comes from. The third of the examples is the Tribunals, Courts and Enforcement Act 2007. This is Authorities, tab 8, page 24. Which sets out the right of appeal. And then if you go on to page 26, at the bottom of page 26, you see the specific provision that before the upper tribunal decides an application for leave to appeal, the upper tribunal must specify the court that is to be the relevant appellate court as respects the proposed appeal. And that is what then came before this court and came before my lord in KP Pakistan. The tribunal had clearly enough specified that that one should go to the Court of Session. So 3 examples.
Clearly is perhaps putting it kindly, but anyway.
I think I said clearly enough. I intended to say clearly enough, and that was that was what led to the outcome of that appeal. And so here, 3 examples of situations where Parliament has said something more specific about that. It's a contrast with the situation that we have, where we've got the plain words of the statute. They have an obvious ordinary language meaning, and there is nothing to displace that. And so we say that supports what we say. Can I then move on to say just a couple of words about Tehrani? I anticipate that the court has already really got these points on board. Tehrani was about something else. It was about the jurisdiction, the judicial review jurisdiction of the Court of Session, as well as that of the High Court, the English High Court, where it was arguable, either might be arguable. And as you see from the decision in Tehrani, it is clear that the Court of Session and the High Court had concurrent judicial review jurisdiction. And so this really was a forum conveniens case.
Well, it wasn't, because no one took the point about forum conveniens.
Or nobody had done originally, yes. And then there were ultimately good reasons for doing something slightly odd, as my lord said. But of course, that just shows how different it is. Here we've got to look at the statute, see what the statute says and what it means. And so Tehrani is of no help at all. So those are what might call the conventional statutory construction arguments. And we say that they all point in only one direction. And that is that this court is the appropriate appeal court. Can I then turn to the last topic, which is the HRA Article 14 and so on? First of all, can I say this? It is not enough for the respondent just to say, well, human rights issues are in play, because we are looking at a question of statutory construction. And if we have got this far, then clearly any human rights arguments are being made to make the statute mean something other than what it says on its face. And so the question is, by what statutory route can you get to a different interpretation of Section 7 from the one which non-human rights arguments lead you to? And we say that there are none. I think it suffices for me to identify the arguments that we have put down on paper and not to go down byways which might be time wasting. The first one is to say that the primary legislation cannot be read in any other way. It literally cannot be read in any other way. Whatever human rights pressures you bring to bear on this. And if that is the conclusion that is reached, then human rights arguments are just not going to change the outcome of this. And we say that allied to that, of course, is that SIAC itself has actually done nothing wrong, because it had no alternative, as I say, to sit in Fieldhouse as directed. But we would also go just one step further than that and say not only can the legislation not be read in any other way, there's actually nothing wrong with the legislation itself, because the legislation contemplates that there can be Northern Irish SIAC proceedings and Scottish SIAC proceedings, and in an appropriate case, within the terms of the legislation, they can take place. This is not a human rights problem caused by the legislation. If there is any difficulty, and if a case really cries out to be heard in one of those jurisdictions, it's the absence of a direction not a problem with the legislation. And so, given that, we respectfully say that, well, first of all, there's no need to read down the legislation if there's no human rights problem with it. But second, there is actually no human rights gateway to reading down legislation that is actually not faulty in human rights terms. So that's the first point.
Well, legislation, if anything, seems to point towards the argument that Lord Chancellor should, where appropriate, give a direction for Edinburgh or Belfast. Otherwise, what's the point of the relevant subsections of sections 6 and 7?
Well, indeed, exactly so. As I said earlier, if there are good reasons for not giving a direction, then the Lord Chancellor could, in theory, be called on to explain those to the Judicial Review Court. The second point is that, as a matter of fact, Sykes' determination was made in England and Wales, and so no amount of human rights interpretation can change the conclusion of that within the clear terms of the statutory scheme. The third point is that the respondent, we respectfully say, overstates what she can do by way of selecting a special advocate. She referred to it as choosing special advocate, instructing a special advocate, and so on. In practice, of course, we accept that the closer that one can get to a situation where the individual is happy with their special advocate and the special advocate is able to receive appropriate instructions, the better. That makes site work better. But that is not actually what happens, because the special advocate is not appointed by the individual, not chosen by the individual. The individual can request particular people, but the ultimate choice and appointment is for the appropriate law officer. And so it is overstating the case to say that the way that the scheme has operated has denied the respondent her choice of special advocate in this case. That is not correct. The fourth point to which we draw attention is that there is no status in play for Article 14 purposes. We have set this out at paragraph 6.5 of our skeleton argument. It's page 36 of the additional bundle. Just to headline them, the first is that you can't claim, as appears in the respondent's skeleton argument, that there's a relevant status because those wishing to appoint English special advocates can, and those wishing to appoint Northern Irish special advocates cannot, because that is an attempt to identify a status which is defined purely by the differential treatment complained of, and it's quite basic that you have to have some independent form of status to form an Article 14 claim. We also draw attention to the fact that there is no differential treatment on the basis of her nationality or residence, because those of every nationality and residence are equally unable to request a Northern Irish special advocate, which is what she would like to do. And for the same reason, that there is no disproportionate effect on those of Irish nationality or residence, because they are no less able to request a Northern Irish special advocate and no more prejudiced than anyone else by the fact that none can be appointed. And it's for those reasons that my learned friend is left, as he did in his oral submissions, left to rely on the proposition that those who are of Irish nationality or residence are more likely to want a Northern Irish special advocate, or would benefit from their special advocate having special knowledge about Northern Irish circumstances. Like Mr. Justice Chamberlain, we respectfully say that it is far from obvious or self-evident that this is the case. if you need to think about what special advocates are there to do. The open advocates are people with whom the individual can have complete and full communication about everything in the case. As in fact, as SITE did in this particular case. Sorry, I was going to say bent over backwards, but that suggests a reluctance which wasn't even there. Very happy for the respondent's choice of solicitors and counsel to appear, the open representatives to appear, because those were the people that she wanted. If you're looking at questions of social circumstances, Northern Irish circumstances, and so on, these are the lawyers and the representatives who will be preeminently best placed to deal with those issues, and they're open issues. In contrast, what special advocates are there to do is to examine the sensitive material in closed proceedings. But technically, special advocates only have a function in closed proceedings. So for practical reasons, we have to blur the lines somewhat in everyday practice. But that is what the statute says they're there to do, to make submissions, etc., in closed proceedings where sensitive material is looked at. Typically, that concerns the national security case. And just taking this respondent's case, national security case, as an example, we know as a headline that she travelled to Syria and aligned herself with Islamic State or Daesh. And that is the core of that is the nature of the national security case against her. It's far from obvious that a Northern Irish special advocate is going to be any better placed to examine and challenge the national security case in closed proceedings than an advocate from any other part of the UK. If there are questions of proportionality, those arguments will inevitably be based on the open evidence and arguments that are advanced or could be advanced by the open representatives. Evidence about the effect on the respondent herself, perhaps on her family members, etc., whatever she wants to adduce. And so we respectfully say that the fact that it's that the special advocates are Northern Irish is really of much less significance than the respondent is trying to make out. I should say a word about Berkeley as well. The focus here on special advocates is the respondent's case. Berkeley was about the judges, and I'm afraid I don't know nearly so much about the actual personalities involved in the different jurisdictions. But one can see that judges might bring something to bear on a case, but that's not the argument here. The argument here is about special advocates and special advocates doing a particular job prescribed by statute in the closed proceedings. So for those reasons, we say that the human rights arguments could not actually get off the ground at all. But even if we were to get as far as the last part, which is justification, we can think, as the Home Secretary's representatives, we can think of a number of obvious reasons why, if there were a need to defend the choice of England or London alone as the venue for SITE proceedings, that could be defensible and justifiable. The first one is that SITE only hears a small number of cases, and so to duplicate or triplicate SITE administrations would be very wasteful. One of the practical consequences of that is the need for secure storage and materials handling, which would also be wasteful to duplicate and triplicate. Third point, Scottish and Northern Irish SITE cases would be only a small proportion of the small number of SITE cases, and that exacerbates the waste involved. The fourth point is the location of the government departments that are typically involved in SITE cases, and keeping SITE in London minimises the logistical costs of running SITE cases. The fifth is that SIAC cases inevitably involve a lot of face-to-face work, both meetings between the government departments and the Secretary of State's representatives, and also meetings between the Secretary of State's representatives and special advocates, and sometimes carrying secure documents with special procedures. If everyone's in London, or has working places in London, that reduces the costs involved there. And then, of course, there are SIAC's closed hearings, and they must take place face-to-face.
So why are there qualified advocates, special advocates in Northern Ireland?
I'm sorry, I missed that.
Why are there qualified special advocates in Northern Ireland if they're never going to be used?
I don't know the arrangements for there actually being Northern Irish special advocates, but I think that the answer is that SIAC is not the only jurisdiction in which special advocates might appear.
Well, there's Justice and Security Act, Section 6.
I think as somebody who does appear quite often in closed proceedings in Northern Ireland, there are a lot of proceedings under the Justice and Security Act
Thank you.
Relating to the Troubles.
Yes.
I'm grateful for that. And the last 2 points are really just to bring in things I've already said. The first is that special advocates deal only with a particular type of closed topics, so there's no need for, in general, for specialist Scottish or Northern Irish experience. And finally, the open representatives, the respondent's choice, or the individual's choice of open representatives can easily be accommodated by SIAC, as demonstrated by this very case. These justification points are really things which would be for a challenge to a refusal, for example, to direct hearings in Northern Ireland. But and of course, I can't speak for the Lord Chancellor. There may be others. There may be different points to make. But these are obvious ones that we can think of as to why London and London alone could be a justifiable choice for procedure. So we say, even if you get that far, that should be the end of any possible human rights interpretation of the statute. Then finally, there are 2 things to sweep up, if I may. The first is that we've made the point that the fact that this hearing was remote is actually irrelevant. A closed hearing, of course, would have to take place in Fieldhouse, and the location of viewers of a remote hearing can't make any difference at all to where SIAC is sitting or where SIAC makes its determination. And then on Lady Justice Lang's 2 questions, I think it's quite clear. We say there can't be concurrent jurisdiction of 2 of the appeal courts. It must be one or the other. And if it is the Northern Irish Court of Appeal that has jurisdiction in this case, we accept that the grant of permission will have to be set aside. I hope that that's been an efficient way of dealing with our submissions. Unless the court has any questions.
Mr. Sully had prepared the ground very thoroughly, so thank you very much, Mr. Tam. Mr. Sully.
Thank you. Can I first apologise? I think my watch just rang. I have a brand new watch, and I hadn't realised I have to put it on silent. Turning to the substance of Millennium Friend's submissions, firstly, Millennium Friend, and obviously I'm going to try and avoid repeating myself, raised the absence of any challenge to the decision of Mr. Justice Chamberlain. There, in our submission, there are obvious issues that would potentially have arisen in relation to such a challenge. Firstly, because it is an interim challenge, it is a CART challenge, and there is the CART threshold that would potentially apply. It was also potentially, by the time any challenge was progressing, it would have potentially been academic on the basis that Sir David Schofield, as he now is, was obviously no longer available. It wasn't necessarily the case that there was going to be a full appeal essentially involving special advocates, because obviously Article 14 was going to be dealt with first as a freestanding issue, and that was going to be open. Whether that was if that had failed, that was going to go straight to an appeal, would have depended on whether or not there was an attempt to challenge it again by way of carte judicial review. So it wasn't, even if it had failed, it wasn't necessarily going to go straight to an appeal. It's obviously very difficult to say at this stage whether there would have been a judgment reached that it was appropriate to challenge by way of carte judicial review or wait, but we simply don't know. In terms of the submission that my learned friend made then, it's important to recognise the determination takes effect throughout the United Kingdom on the basis that the appellant is, or the respondent rather now, is excluded from all parts of the United Kingdom. In one sense, I accepted that because I accepted immigration law applies throughout the United Kingdom. The question, perhaps as rephrased by me, is in our submission though where the closest connection was, and our submission remains obviously that as a matter of fact on this case, the closest connection is plainly with Northern Ireland. That leads into the submission my learned friend made, which is that this is potentially a vague concept, but it's not a concept that the courts don't grapple with from time to time, as Tehrani demonstrates. Courts are equipped to determine that. When they're dealing with forum arguments, they do deal with that. In our submission, it is something that lawyers and courts do grapple with. And obviously, if in our submission, if there is, it's unlikely to cause any unfairness to the Secretary of State. I mean, if this court were to conclude that it lacks jurisdiction, without necessarily conceding the point, it's highly likely one would think that the Court of Appeal in Northern Ireland would conclude there's good reason to extend time. Whether it adopted the judgment of Lady Justice Laing and granted leave to appeal, I don't know, but one can see that the court is likely to be influenced by what's happened in England. In terms of the solution being essentially that we could request a hearing in Belfast, the problem in our submission with that is, as my learned friend identified, the Lord Chancellor may have practical objections to a case taking place physically in Belfast. That doesn't necessarily mean that arrangements shouldn't and couldn't be made for Belfast judges to, in particular, hear appeals. As I've already indicated, there's plenty of experience in Northern Ireland of dealing with closed procedures, and I'll come back to that. The learned friend then made the submission that Parliament could have made contrary provision and cited three provisions. The first was the Immigration and Asylum Act, which makes it clear that it is the determination of the adjudicator essentially determines location. But what that does essentially is use the same language as is used in the SIAC Act. It refers to the determination of the adjudicator, but it does that without identifying how one determines where the determination of the adjudicator takes place. Under that legislation, the same issue arises, which is, do you adopt an approach which simply focuses on the physical location of the adjudicator, or do you look at the Tehrani approach? In terms of the Competition Act and the Tribunal Courts and Enforcement Act, both of those essentially identify a process for determining the appeal route. They don't identify the test. And what is significant in one sense about those pieces of legislation is they demonstrate how physical location may not be determinative, because if there wasn't the need for alternative routes to be established, other than those that arise from the physical location, there'd be no need for a process for determination to be identified. In terms of the human rights arguments, my learned friend says it's not enough for us to say human rights are in play. We submit, and it's probably implicit in what we said about domestic law, that Section 3 interpretation is possible in this case, because of the argument essentially that we put in relation to domestic law, that this statute can be read in a way that means that a range of factors are essentially taken into account in determining where the determination was. In terms of the argument that the legislation is not the problem because the legislation permits litigation in devolved jurisdictions, the argument essentially the issue is the absence of a direction. Our argument is that the legislation effectively distinguishes potentially between the test to be applied when the approach of the Lord Chancellor and Section 6 and Section 7, and the direction may not be made for practical reasons. When one looks at the case law about the upper tribunal sits only in London for practical reasons. That doesn't necessarily mean that in our submission should be determinative as to where an appeal takes place. My only friend then says in the human rights case, in the context of the human rights argument, we overstate what the appellant can do or the respondent can do in terms of choosing a special advocate. In our submission, what is critical is, as my learned friend accepts, is we have the opportunity to nominate who we wish to be appointed as special advocate, or the respondent has that opportunity. As I already indicated, if that is just refused, it must be on good grounds. Now, there's obvious reasons for the law officers to have a role in that, but fundamentally, that has to be exercised in our submission in a manner that takes account of the choice of the individual, given the right generally to have a counsel of one's choice. Turning then to the issue of whether there was status, my learned friend refers to paragraph 32 of our skeleton argument. Paragraph 32 is where we identify the difference in treatment. It's not where we identify the status. Status is identified in paragraph 33. And that's the context in which we identify nationality or residence as being the status. Now that links in essentially to my learned friend's argument that there's no particularly good reason for Irish residents or nationals to want a Northern Irish special advocate, and he argues essentially that open advocates will be best placed to deal with the sorts of issues that arise in relation to residence and nationality, and the special advocate is essentially only dealing with closed and only dealing with national security. Aside from the point I already made in opening about the importance of confidence, in our submission, national security needs to be addressed in part because it will feed into proportionality. My learned friend says proportionality will only be addressed in open. We submit that's not necessarily true. For example, were there to be evidence, and I recognise this is speculative, I have no idea what the closed material in this case is, but were there to be evidence, for example, from an informer, where the informer said, among other things, there's no reason why this couldn't happen, that an individual really hated travelling to Northern Ireland. The reason they wanted to travel was because they wanted to go to England, for example. That would potentially be relevant to proportionality because it would undermine the open evidence of the individual about why it was important to them to travel effectively. If the individual was saying to the informer, I have no interest in seeing my family in Northern Ireland, I actually just want to go to London to let off a bomb, that would be closed material and it would be highly relevant to proportionality. And so proportionality can be addressed in closed. Because ultimately what is happening in closed, which is why proportionality is so important, potentially in closed, is that it's only in closed that people will see the full scope of the justification and be able to set that against the individual's interests in coming to the United Kingdom or remaining in the United Kingdom. So in our submission, one can't distinguish between open and closed in the way that my learned friend seeks to do. And that's why it's important to the individual, potentially, that they have their advocate of choice. Turning then to the final point my learned friend made, which is he said that the choice of London essentially is defensible. He relies on the small number of cases and the location of government departments. 3 points that we would make about that. Firstly, it is clear that Northern Ireland does manage to cope with closed proceedings. It does that, as I say, in the context of Justice and Security Act cases, and it does it in cases where the issues may have a Northern Irish flavour. They're often, I would accept, to do with the Troubles, but obviously the reason why national security is raised is because, in part, those Trouble-related cases raise issues about the actions of the security services in Northern Ireland. And so Northern Ireland does cope effectively with closed procedures. But secondly, more importantly in one sense, if there is a legitimate practical reason why SIAC needs to sit in London, that supports our argument that physical location should not be determinative of special advocate appointments and appeal rights, because physical location may be determined by those practical considerations, but the legal issues may require the involvement of Northern Irish special advocates and the involvement of the Northern Irish Court of Appeal. One final point I'd make is that many of those arguments effectively focus on the lack of resources, and one has to be careful about resources in this context in our submission, because ultimately this is a procedure that places significant disadvantages in the way of the appellants because of the interests of the state. In those circumstances in our submission, the state has to be very careful to ensure that proper resources are available to ensure that there is no disadvantage to the individual. So one does have to be very cautious about resource arguments in our submission. So for all those reasons, in our submission, those practical issues that my friend identified are not, we would submit an answer to our case. And in particular, what they suggest is that physical location shouldn't necessarily determine the key issue in this case, which is appeal right. I think that probably covers everything I need to say. Thank you. Thank
you very much, Mr. Southey. We're grateful for the oral submissions. We're also grateful for the written submissions. And Ms. Smythe, it's a pleasure to see you in this court, even as a visitor. I should have asked you after Mr. Southey's first address, and similarly Ms. Barnes, if you had anything to add. That tradition has slightly worn thin recently, and usually junior advocate smiles, gets up and bows, and that's it. But I apologise for not doing that, particularly in your case. Mr. Tam, did you want to add anything? No. Right. Is the if the case is to stay in this court, is the appeal listed?
Yes. There's an appeal date in February, I think.
Yes.
Yes.
First of February.
Well, I think you need the answer, if not the reasons, pretty well immediately, because we'll just go outside and discuss the matter and see if we can give you the answer, and then everyone know where they stand. Thank you.
Votes rise.
I should have moved that. Well, some do, some don't. And it was actually quite funny because I was here a couple of weeks ago, and I had a really quite experience with who was completely baffled by being asked. He's talking about it.
Daniel had emailed us, did you see that?
No.
Saying he had someone was nearly slipped out. Or one. Well, yeah.
I've been forced to. I have major cardiac issues over 3 years ago. My cardiac team want me to have a smartwatch so I can check my heart more regularly. Because I like exercise. I was due to do the London Marathon, I had to pull out at the last minute. Because they want me to have a smartwatch so I can check my heart, which is what I was actually doing. I was just checking. This is the first time I've worn it since it was before. But I forgot they ring.
Well, what did it say?
Oh, my ECG was fine.
You're all good.
Yeah.
It was quite quiet though, Hugh.
It was,
Fair to you.
but okay,
You
but,
were
it,
lucky.
but it's my cardiac. They want me to wear a smartwatch so I can check my heart. And this is the first time I've been in court since. So I was checking. I checked my ECG immediately. I had to sit down because I wanted to see whether it was troublesome. It apparently isn't.
Pause, Chris.
We have reached the decision that Lady Justice Laing was right, that the appropriate appeal court is this court, and that therefore the full appeal in this case listed for February should go ahead. In deference to the very helpful and clear arguments we've had from each side, we won't attempt to give a judgment off the cuff this afternoon, but that will be with you as soon as practicable, as all the experienced advocates in the case know. That's not for re-argument, it's only for correction of typos and obvious factual errors, it's subject to the usual embargo identified in the Counsel General for Wales case. Thank you all very much indeed.
Pause, Chris.